A former governor of Niger State, Alhaji Babangida Aliyu, appeared at the Federal High Court, sitting in Minna, on Monday, January 22 over an alleged N2bn fraud case for which he is being tried before Justice Umar Nasko. The court however adjourned the case to February 20, 2018. Fondly called the chief servant while he was governor, Aliyu is being prosecuted by the Economic and Financial Crimes Commission, EFCC, alongside his chief of staff, Umar Nasko, on an 8-count charge of abuse of office and money laundering to the tune of N2bn. A statement by the EFCC said the money, which was said to be part of ecological funds released by the federal government to the state in 2014, was allegedly diverted by the former governor for political purposes. The offense, the statement obtained by We Said, is contrary to Section 18A of the Money Laundering Prohibition Act, 2011, as amended, and punishable under Section 15(3) of the same act. Slated for January 22, the trial was stalled by the defense counsels under the claim that they could not understand the statement made by PW1, Sayyid Umar Idris, before the EFCC. Nasko's counsel, Umar said that he could not decipher the statement of the PW1, a position which Aliyu's counsel, Alhaji also aligned himself with. Osuman reportedly said, "My lord, this gentleman's purported statement before the EFCC is contained on a page within the ambit of proof of evidence. We are not able to decipher this statement. We can't read it, we can't understand it, and a criminal matter is not supposed to be an ambush." He also prayed the court to compel the prosecution to oblige them with a comprehensive copy. In his response, the counsel to the EFCC, Ben Sikani, vehemently opposed the submissions of the two colleagues, arguing, the PW1 is the primary evidence as required by law, and his statement was served on the defense 6 months ago. What the law always look for is primary evidence. And who is the primary evidence here? It is the witness himself, of course. For goodness sake, my lord, 6 months after the proof of evidence has been served on the defendants, they did not say anything. They ought to have put across to the prosecution the question of whether the statement is readable or not before now. None of them complained, and they waited till this time when prosecution is ready to open its case and the court is ready to go on. We learned that Ikani said he had a readable copy in his file and urged the court to disregard the submissions of the defense. While adjourning the case, Justice Bogro ordered the prosecution to make and serve on the defense copies of all the statements of the PW1, so that trial can progress. We earlier reported how the Economic and Financial Crimes Commission arraigned Ijeoma, a woman alleged to have defrauded her victim of N4 million before Honorable Justice Babangida of the Kano State High Court. Ugwa was arraigned on a count charge of obtaining by false pretense after she was alleged to have received the sum of N4 million from the complainant under the pretext that she would secure him a job in the Goodluck Jonathan administration.